Fate of a case, my junior colleagues, depends upon how well you've conducted the trial of that case. By trial, I mean the examination of the witnesses particularly. So examination in chief, cross-examination and re-examination. You must have read at length and breadth about these concepts. You must have seen your seniors conducting examination of their respective witnesses. However, there is a reason why it is called an art, because it needs to be polished every day in order to master it. So let's first understand the term examination in chief. It is basically done by the party who is calling that witness. So the goal is to get the witness narrate the story which we want the court to believe in. So the questions which need to be asked to such a witness are supposed to be open-ended in the form and nature and not leading questions. So no matter how many trials you must have conducted in your career, but then still at times you get confused whether I'm asking a leading question or not, because the moment you ask a leading question, you should expect that the question will be challenged, an objection will be raised. So the best rule to follow in order to avoid any leading questions during examination in chief is to ensure the question that you put starts with what, why, where and whom. So for instance, there is a POCSO case and the witness is before you. Put question to the witness which would be like, who all accompanied the accused at the place of incident? Where were your parents at the time of the incident? So the question would be answered in a narration form. So, another trick that you're not asking a leading question is that the answer to your question should not be hidden in the question in itself. For example, in a theft case, for instance, you question the witness, ये वही शख्स है ना जिसने तुम्हारी घड़ी चुराई थी. So it's like you are asking the witness to answer the question to which you've already answered, which makes no sense, and it's a leading question. So you could have just said that, तुम्हारी घड़ी किसने चुराई थी. So let the witness answer, let the witness narrate your story. Now it is the cross-examination where the opposing counsel comes into picture. He probes the witness to test his credibility, to highlight the inconsistencies, and to extract the facts favorable to his case. Now is the time when you're asked the leading questions, because if now you ask open-ended questions, it would become fatal and detrimental to your case, because the witness will use every opportunity to fill in any gap that he would have left at the time of examination in chief, which we as a defense counsel would not be able to afford. So the questions would come in the form like, isn't it correct that you didn't immediately report the matter to the police and it took you 3 days to report it? क्या ये सही है कि ये वही इंसान है जिसके अगेंस्ट तुम्हारे फादर ने भी पहले केस किया हुआ था? So basically it would show the background there is behind the prosecution. So any question asked, you ensure that the answer should only come in yes or no. It should be framed in such a manner. Re-examination is seldom used in order to basically re-establish any fact which has been displaced during cross-examination. Suggestion is a very powerful tool that is used to challenge the testimony of the witness. Now, the suggestion is always in a statement form. So, for instance, in an NDPS case, the investigating officer is before you, so you give the suggestion that I suggest that you were not present at the time when the contraband was seized. So, the fact that you want to establish as a cross-examiner has already come in the form of the statement that you've put across. Suggestion basically fulfills two purposes. It puts a doubt in the witness's account and it gives an alternative narrative. So always prepare thoroughly and anticipate the responses by the witnesses. Open-ended questions during examination in chief and leading questions during the cross-examination. Strategically use the suggestions in order to challenge the testimony of the witness. Objections, if at all, are to be used timely and have to be valid objections. Avoid any common pitfalls like focusing on the irrelevant areas during the time of cross examination. Stay composed and respectful, the judge is watching. All the best.